Good evening, everybody. Please allow me to introduce myself. My name is Greg Kitrov. I'm the owner of Vintage Arms and Vintage Arms Training Center. My background combines firearms training, FFL retail experience, gunsmithing support, and emergency medical experience. My goal is to promote safety when it comes to firearms, responsibility, lawful ownership, and practical education. Today, I would like to provide you an overview of New York Penal Law Article 35 with special attention to duty to retreat. The goal is a safer decision making, better understanding, and knowing when to seek legal counsel. Nothing in this presentation is legal advice, and that anyone facing a real incident should consult a New York attorney. Our recommendation is Peter Tillum of New York Tech Defense Group. Please pay attention to the disclaimer once again. This is for any legal service advice, please contact a New York attorney. Here's the contact information for Peter Tillum at newyorktechdefense.com. Article 35 is extremely fact-specific, and that small differences in facts can change the legal analysis. We, as instructors or gun safety instructors, can discuss general concepts, but only an attorney can advise someone about specific incidents, investigation, charge, or licensing concerns. Look at Article 35 as the justification defense framework. It doesn't give you a blanket permission to use force. It describes when force may be legally justified. Once justification is properly raised, the prosecution generally has the burden to disprove it beyond a reasonable doubt. But that does not mean every use of force will be accepted as justified. Distinguish physical force from deadly physical force. Physical force has a lower threshold, but still requires necessity and reasonableness. Deadly physical force is treated much, much more seriously, and the duty to retreat issue mainly appears before deadly force is used. Threatening or using a firearm can quickly push an encounter into a higher risk legal category. It's a two-part idea. The person must actually believe force is necessary, and that belief must also be reasonable under the circumstances. For example, a rapidly changing confrontation where force may be justified at one moment, but not later after the threat stops. Perception, evidence, witnesses, video, injuries, distance, and opportunity to avoid the fight all matter. This is one of the most important points in this presentation. New York is not, and please allow me to emphasize, not a broad stand your ground state when it comes to the use of deadly physical force. Before using deadly physical force, if a person knows they can retreat with complete personal safety to themselves and others, they generally must do so. The key words are knows and complete personal safety. The law does not require someone to gamble on a dangerous escape route, but it does require retreat when the safe avenue or escape is clearly available. Please remember what we teach in the 18-hour CCIA course, that a firearm is a tool of last resort. The threat must be imminent before you use it. The danger must involve death or serious physical injury, and there must be no safe way to avoid or escape the confrontation. So here are some of the major exceptions. For example, in the dwelling, there's generally no duty to retreat if the person is not the initial aggressor. Law enforcement and certain serious crime provisions are separate statutory categories. Let's try to make it clear that an exception to the retreat rule does not make deadly force automatic. Necessity and reasonableness remain part of the analysis. People often hear castle doctrine language, but New York rules have specific statutory wording. Being in a dwelling or your home may remove the duty to retreat, but It does not authorize revenge, punishment, or force after the danger is over. The law has a burglary-related deadly force provision, but the actor still must reasonably believe force is necessary to prevent or terminate the burglary. In other words, if someone breaks into your home at 3 o'clock in the morning and you happen to have a shotgun that you racked, the aggressor or the person who broke into your house now has kind of a come to Jesus moment and decides to leave, please let him go. Please don't shoot him in the back and don't drag him back into the house. Just let him go and call the police. Please also note the initial aggressor rule matters. If a person starts the fight, provokes it with intent to cause injury, or escalates it, justification may be limited or unavailable. Withdrawal. If the person clearly withdraws and communicates that withdrawal, look, I don't want to fight, I want to leave, I got the wrong house, but the other person continues unlawful force, the analysis may change. Please avoid confrontational language, chasing, blocking exits, or re-engaging once they can safely disengage. Here's a good mental checklist. The key questions are, am I facing an unlawful force? Is deadly force actually necessary? Can I safely retreat? Does an exception apply? And am I using only the amount of force necessary right now? The practical lesson is that avoidance, distance, de-escalation, and calling 911 are usually better than trying to win a confrontation. Also a lot less expensive than using a deadly force. Here's some of the common myths, and let's correct them. New York does not allow a person to stand their ground everywhere if safe retreat is known and available before deadly force. The home is important, but the home exception does not erase the requirement of necessity and reasonableness. Also, I'd like to emphasize that justification can end if the threat stops. And if the threat stops, force must stop. Article 35 is a defense framework, not a permission slip. Duty to retreat applies to deadly force when complete safety is known to be available. Exceptions matter, but they do not eliminate reasonableness. The best mindset is to avoid being the initial aggressor. Disengage when possible, stop when the threat stops, and contact counsel after any serious incident. Please also always check primary sources. Don't go by videos on YouTube or Facebook posts. Please check the New York State Senate open legislation pages for Penal Law Section 3515 and 3520, and the New York Court's criminal jury instructions. I encourage everyone to verify the current law because the statutes, case laws, jury instructions, and local practices can change. And in closing, I'd like to remind you that Vintage Arms provides training, safety education, application services, gun purchase support, gunsmithing, and out-of-state license information. Once again, this presentation is informational only and not legal advice. I would like to invite you to contact us for training, licensing support, purchasing your firearm, while directing you for legal questions about real incidents to qualified counsel. I want to thank you very much. It was an absolute pleasure, and have a good night.